Hadi ya, biz de buna güvendik ya.
Yes, welcome to the second session today, afternoon session of our third radio room meeting. It's a great pleasure for me to be here as the moderator of this session. Our panel is titled Disputed Maritime Zones. And we have some 80 minutes since we finished our lunch a little bit later and gave some time for the family photo. So I will ask for all of our speakers to make their presentations within a limit of a quarter of an hour, which means 60 minutes. And without further ado, I would like to give the floor to Ambassador Çağatay Erciyes, who will speak about Eastern Mediterranean Sea. Ambassador Erciyes is a prominent member of Turkish Ministry of Foreign Affairs, and he is the General Manager of Aerospace and Maritime Issues in the Ministry. Previously, he served as an ambassador in Beirut, and just a few weeks ago, he was appointed as the next ambassador of Turkey in Athens. So the floor is yours, Mr. Ambassador.
Thank you very much.
No microphone.
Is it fine? Thank you. First of all, it's a great pleasure for me to be here to address such a distinguished audience. And I'd like to echo what the previous speakers said. I'd like to express my warmest gratitude, congratulations, and appreciation to DEOKAM and the Turkish Law Platform. I am so happy that the Turkish Law Platform, the distinguished judges and the lawyers, picked this year the law as a theme.
Go forward. Is the text çözüldü mü?
The translators, are they hearing my voice? Are they translating? Where are the interpreters?
I think the problem is not technical, but humanitarian, we don't have interpreters.
After the family problem, I thought that. There is a system problem, and it was 5 minutes. We will fix it.
İsterseniz bekleyelim. Çünkü onsuz devam edemeyiz.
Ses. Okay. Translation. Thank you so much. It's a great pleasure for me to be here with you to address such a distinguished audience. I'd like to join the previous speakers in thanking the UCAM and Turkish Law Platform. I'm so pleased that this year's theme is the law of the sea, and I believe we should continue to have similar panels in the years to come, because Turkey is surrounded by 3 seas and the law of the sea is very important for Turkey. And I'm so happy that now, as DEUCAM and the Turkish Law Platform, we are focusing on the law of the sea issues. So thank you very much for supporting DEUCAM, and please keep supporting them in the years to come. My theme is the situation in the Eastern Mediterranean. I'd like to summarize the position of Turkey, the legal and political position of Turkey with regard to the situation in the Eastern Mediterranean. In the previous panel, there were some questions. As I go through my presentation, I'll try to answer those questions as well. The Eastern Mediterranean. If you look at the map, you see that there are 10 countries surrounding the Eastern Mediterranean, including Palestine and the Turkish Republic of Northern Cyprus. The territorial sea limit in the Eastern Mediterranean, 6 to 12 nautical miles. It's a semi-enclosed sea. It's not like the South China Sea or East China Sea, where there are vast maritime areas. There are overlapping maritime boundary claims, and there are international issues such as the issue of the Cyprus issue, Middle East issue, and it's also an energy flashpoint. Well, I think Professor Karan mentioned this. Maritime boundary delimitation is the most common dispute between the states in the world. I think in the previous panel, there are 400 maritime boundary delimitation issues in the world, and those issues are generally dormant issues until the coastal states compete for natural gas and oil. Whenever the oil and gas is discovered, then the coastal states compete for maritime boundaries as well. This is exactly what happened in the Eastern Mediterranean. We didn't talk about maritime boundary delimitation in the 1980s or in the 90s. Everything started in the 2000s, almost 20 years ago. These are the discovered natural gas fields in the Eastern Mediterranean earlier. And how did it all start? It all started with the unilateral steps of the Greek Cypriot administration. The Greek Cypriot administration, the Greek Cypriots, signed maritime boundary delimitation agreements with the neighboring countries before the settlement of the Cyprus issue. They concluded an agreement with Egypt in 2003, then with Lebanon in 2007, and then with Israel 2010. Turkey and the Turkish Republic of Northern Cyprus objected to those agreements, and they registered their opposition through the United Nations as well on two grounds. The first ground was the very existence of the Cyprus issue, and the second ground was that we felt that the agreement concluded between the Greek Cypriot administration and Egypt violated Turkey's continental shelf rights. Cyprus issue. The Cyprus issue, you know, maybe I have to say a few words about it. Republic of Cyprus. We talk about the Republic of Cyprus, but the Republic of Cyprus does not belong only to the Greek Cypriots. The island was an Ottoman island in the past, then the British got the sovereignty of the island, and in 1960, when the Republic of Cyprus was established, British ceded the sovereignty of the island to the two people on the island, the Greek Cypriots and the Turkish Cypriots, and a partnership state was established based on the sovereign equality and equal international status of the two peoples on the island. But this partnership state lasted only for 3 years. In 1963, the Greek Cypriots occupied the Republic of Cyprus. They ousted the Turkish Cypriots from the government organs, and the international community made a big mistake. The occupier was rewarded, and the victim was punished in 1964. Despite the coup d'etat in the island, the Greek Cypriots were recognized as the legitimate representatives of the island. So that's why we cannot resolve the Cyprus issue. Both peoples on the island are equal. They have equal sovereignty. They have equal international status. Unless this is reaffirmed by the UN Security Council, there is no new negotiation process. This is the position of the Turkish Republic of Northern Cyprus, and Turkey fully supports this position. So, how did it start in the Eastern Mediterranean? As I mentioned, the Greek Cypriot administration made 3 maritime boundary delimitation agreements, and they started unilaterally offshore activities. They launched seismic surveys, they drove offshore blocks, and they did their first drilling in 19 September 2011. That was a turning point. From 2003 to 2011, Turkish Cypriots and Turkey were saying that these issues should be deferred to the settlement of the Cyprus issue. But when the first drilling started, we and the Turkish Cypriots changed their position. Turkish Cypriots made a similar agreement, delimitation agreement with Turkey in 2011 after 2 days. And the Turkish Cypriots, like the Greek Cypriots, drove offshore blocks, and they authorized the Turkish Petroleum. They couldn't find any other international oil company. They found Turkish Petroleum, and they authorized the Turkish Petroleum for survey and drilling activities. These are the offshore licenses between 2007 and 2012. Licenses granted by Turkey, Turkish Cypriots, and the Greek Cypriots. And in 2011, Turkey didn't have the capacity, too much capacity on offshore exploration and drilling, but as the government invested a lot. Turkey is now among the few countries in the world who has the ability to conduct offshore survey and drilling. Now we have 4 drilling ships and 2 offshore survey vessels. These vessels are very modern and 6th, 7th generation drilling vessels. This is Turkey's and Turkish Cypriots drilling activity. So far, there were 8 drilling in the areas, in the Turkish continental shelf and in the areas of Turkish Cypriots licensed areas. Let's look at the claims, maritime boundary claims. This is the Greek Cypriot continental shelf EEZ claim. This is the Greek claim in the Eastern Mediterranean. As you see, a huge area giving full effect, full entitlement, even for the rocks. And this is the continental shelf and EEZ of Turkey declared to the United Nations. There are 2 agreements. One is mentioned in the previous session. One is the Maritime Boundary Delimitation Agreement that we concluded with Libya in 2019, and another one with the Turkish Republic of Northern Cyprus in 2011. And this is the overlapping maritime boundary claims in the Eastern Mediterranean. And let me now speak, before analyzing those maps, let me speak of the international legal framework. I'll try to be quick because in the previous panel, Admiral Kutluk and other speakers mentioned about the rules in international law governing the maritime boundary delimitation. Let's look at the arguments. The Greek arguments is that all islands, regardless of their geographical position, whether they sustain human habitation or not, should generate full maritime zones. This is the Greek maximalist Greek position, and they believe that median line, equidistant line, should be the method for the delimitation of maritime boundaries. And they base their argument on Article 121 of the Law of the Sea Convention. This is the regime of islands. According to that article, islands can generate, with the exception of the rocks, full maritime jurisdiction zones, including territorial sea, contiguous zone, continental shelf, and EEZ. But the question is that entitlement is one thing, delimitation, maritime boundary delimitation is another thing. As far as maritime boundary delimitation is concerned, the principle is, the governing rule is the principle of equity, equitable solution, equitable delimitation. And median line, equidistant line, is not mentioned in the Law of the Sea Convention as a method. If you look at the relevant articles of the Law of the Sea Convention, Article 74 and 83, we see the principle of equity in there, equitable solution. And I don't want to go into details because we are lacking time. But the question is whether the equity is defined in the law of the sea convention, and the answer is no. We have to look at the jurisprudence of international courts, and when you look at the jurisprudence of the courts, there are several factors that the courts take into account, whether the delimitation line is equitable or not. These are the factors that the courts take into account: geographical circumstances, non-geographical circumstances, and other factors. But I want to highlight two factors: the presence of the islands and the coastal lands are two factors that Turkey attaches great importance in maritime boundary delimitation. And if you look at the jurisprudence, if the presence of the islands distorts equitable delimitation, then the courts, we see that in the many decisions and also in the state practice, the islands can be ignored. So there is no automaticity in giving full effect to the islands. I don't want to go into details of the jurisprudence, but these are just a few examples. Lydia Malta. So when we look back at the Greek claims, according to Greece, Turkey has no continental shelf in the Aegean Sea. And according to the Greek arguments, all the islands, regardless of their position, geographical position, although they are far away from the mainland, they should create full maritime jurisdiction areas. This is one example that we always use, even my minister always uses this example. There's a small island in the close vicinity of Turkey, Castellori's Island, or known as Meis Island. This island is 2 kilometers away from the Turkish coast. It's a small island, 10 square meters. According to the Greek position, this island should generate 40,000 square kilometers of maritime jurisdiction area. I don't think that this is an equitable position. Also, the position that also interests Libya as well. Greece issued licenses in the south of Crete and in the west of mainland Greece. And when they are issuing those licenses to international oil companies, when they are drawing those licensed areas, they gave full effect to the small islets and rocks in the south of the island of Crete as well. This is just one example that I put on the map. Let's go back to the questions. This is the MOU that we signed with Libya in 2019. We drove a delimitation line between the two countries in 2019. And Greece responded to that agreement with signing an agreement with Egypt in 2020. Now there are overlapping claims in that area. There was a question this morning whether the government of Libya is eligible to conclude agreements or MOUs. I have to mention that our agreement MOU in the form of MOU was registered to the United Nations, but it wasn't only Turkey who concluded MOUs with the government of Libya. I think so far there are 41 MOUs concluded with the current government. for example, Egypt was very vocal against our last MOU. Egypt concluded 25 MOUs with the government of Libya. So there is a double standard here, especially in the European Union. The last agreement, the last MOU that we concluded with Libya was about cooperation, onshore and offshore hydrocarbon cooperation between the two countries. There were similar agreements concluded even by some European countries. So I think Europe was under too much influence of Greece to make a fuss about the last agreement that we concluded. 2 minutes. This is very important. The recent agreement, I think Admiral Cook mentioned this in his presentation. I was the Turkish ambassador in Lebanon. Lebanon and Israel concluded a maritime boundary delimitation agreement very recently on 4 points. This is as the Turkish Foreign Ministry will welcome this agreement. It's also it's another model of joint development through a third-party operator. This can be a good example for the future for the region as well. I won't go into detail, but what can be done in the Eastern Mediterranean? We see that there are attempts aiming at excluding Turkey, like EastMed Gas Forum, excluding not only Turkey but also the Turkish Cypriots as well. As President Erdogan and Foreign Minister Çavuşoğlu mentioned in the past several times, and any attempt excluding Turkey and Turkish Cypriots will not be successful in these. If there is to be a cooperation, this cooperation should be inclusive and it should be a genuine cooperation. So President Erdogan made a proposal in 2020. He proposed to hold an inclusive EastMed conference with all the stakeholders, not only the coastal states, but also the states whose companies are operating in the region. This proposal is still on the table, but it was not responded so far, especially by the European Union. Another important cooperation proposals are those of the Turkish Cypriots. Turkish Cypriots made hydrocarbon cooperation proposals to the Greek Cypriots, 4 proposals since 2011. The last one was cooperation to international oil companies in 2022. It is very similar to that of the model agreed between Lebanon and Israel. Those proposals are still on the table, and it could be a good way out between the Turkish Cypriots and the Greek Cypriots. This is my last slide. What is the MDD? What would be the MDD scenarios in the Eastern Mediterranean? Actually, there are 4 scenarios. We can live with the overlapping plains, and we can agree to disagree. This is one option. The other option is to conclude maritime boundary delimitation agreements. We are open for that. I haven't touched upon the Egyptian issues because we don't have much time on the Egyptian issues, but Turkey is prepared to enter into meaningful negotiations with Greece on the Egyptian issues. The other option is joint development, joint management. This is a model which has been applied since 1974. The first model was between South Korea and Japan. There are 23, 24 examples in the world. The last example is the Israeli 11-1, and this can also be a good model. And the last option would be to take those issues to the International Court of Justice or adjudication. That can be a way out. This is also the practice in the world. But as far as the EJ issues, Turkey is not ruling out ICJ based on the mutual consent of the parties, but it is Greece who is preventing the referral of those issues to the ICJ. They have reservations on 3 EJ issues: the airspace limit, the demilitarized status of the Eastern Aegean Islands, and also the maritime boundary delimitation issues. They have reservations. So I thank you very much for your patience. If you have any questions, I'll be happy to answer them at the end of the panel. Thank you so much.
Thank you very much, Ambassador Karacic, for summarizing Turkish legal points of view in the Eastern Mediterranean and the recent political developments. I'm sure there will be a lot of questions after the panel. Now our second speaker is Mr. Neil Silva, who will speak about South China Sea. Neil Silva is a legal officer at the University of Philippines Law Center, Institute for Maritime Affairs and Law of the Sea. And he is a lecturer on constitutional law, legal history, legal theory, and peace process, and transitional justice at the University of the Philippines College of Law. He is also a trustee of the Foundation for the National Interest and has lectured at the National Defense College of the Philippines and the Development Academy of the Philippines. He previously served in various staff-level capacities with the Department of Justice and the Energy Regulatory Commission, and was a consultant of the National Coast Guard Council, Secretariat, and Senate Committee on Foreign Relations. The floor is yours.
Okay, good afternoon, everyone. First of all, I would like to say this is a great honor for me to be invited to this august event. Also, I must say I consider myself to be very much a dwarf in the company of very esteemed giants of academia and the civil service of your respective states. So please allow me to say whatever I say, but please feel free to correct me in case there is anything I say that is incorrect. I would welcome your correction and your amendments. So this topic is concerning the South China Sea as a contested area. As you noted, there are many issues in the South China Sea which are overlapping, including not just law but also geopolitical issues. But because we have 15 minutes, I've had to pare down a 150-page slide into, I think, less than 20, and we will pare it down further. So this slide is only my personal opinion, I must say. Now, this presentation will have 3 parts. Number 1, will it be a very, very broad and very quick summary of the various issues in the South China Sea. Number 2, will be the global implications of the regional issues in the South China Sea. And number 3, what are the possible ways forward for the Philippines, for the region, and for the world concerning the South China Sea, which, as we know, is one of the major flashpoints in the world today. So, in lieu of a 120-page slide, this slide is the master slide for the many, many issues in the South China Sea. The circle on top is specific legal issues, mostly area disputes. The circle on the left is systemic legal issues. Specific legal issues, systemic legal issues. The circle on the right is systemic political issues. What are the specific legal issues? There are territorial disputes, many of which are a result of colonial era disputes between France, between China, and Japan up until 1951. there are systemic legal issues, like for example, the binding force of UNCLOS as maritime zone and dispute settlement, as well as the regional and the global rules-based order, a topic that we can discuss further. And in between, an overlap of specific and systemic legal issues is the use of the 9-dash line by the People's Republic, and also their proposal of a 4 shots theory by their academics. Now, the systemic political issues are the fact that South China Sea represents a security as well as economic interests, specifically as part of the so-called island chain strategy of China. And if you subscribe to the McKinder thesis, this is a major part both of the defense as well as the offense of China, as well as the contest of regional primacy and global primacy between China and the United States, and the United States as allies and emerging allies and partners. In between the systemic and political and legal issues, you have the use of quasi-warfare methods. I don't use the word gray zone because gray zone only encompasses illegal but non-warlike. But there are also not legal but non-ethical practices, as I hope I have time to discuss, or if not, I can discuss it after that. And then, in between specific legal issues and systemic political issues, you have China's attempt to assert greater and greater control over activities in the EEZ, specifically military activities in the EEZ. And finally, in the middle of everything is one question. Will the South China Sea be the mare clausum or the mare internum of the People's Republic of China? Now, this is actually a very bare-bones summary of the issues. To note the fact that there are many territorial disputes, and this highlighting some of them: Scarborough Shoal, Paracel Islands, and Spratly Islands. And then there are various maritime overlaps. Number one, there are overlapping UNCLOS base, EEZ, and continental shelf in the northern South China Sea, as well as in the southern South China Sea. And then there are overlapping extended continental shelves, or continental shelves beyond 200 nautical mile claims. We already saw the joint submission of Malaysia, Vietnam, Malaysia, and then there are also pending overlaps. And of course, the islands themselves, general territorial seas. Now, I'd like to highlight one of the major overlap, which is not caused by an UNCLOS compliant maritime zone, but by China's attempt to create a 9-dash line as a maritime claim. I must say that when I say China's attempt, it has never been clarified. The People's Republic has never clarified what it means. Originally, it meant a claim to the islands. That was the 1935 claim and 1947 claim. But sometime later, it became a claim to the waters within that vast line in the South China Sea, notwithstanding the great distance from the mainland of China. Aside from that, you have the emerging 4 shots theory, which the legal basis of which was refuted by the U.S. State Department in Limits of the Seas 150, showing how the idea of proposing China as an archipelagic state with archipelagos is contrary to the fundamental principles of UNCLOS, especially the fact that only an archipelagic state can have archipelagos, rather than a mainland having offshore archipelagos. And another thing that has to be noted as both a legal issue as well as a political issue is the emerging use of quasi-warfare methods. I have taken here the traditional DIME, this diplomatic, informational, military, and economic levers of power. We add to the non-military physical, meaning Coast Guard, white ship, exploration ships, military vessels, as well as the legal use of law or juridical lawfare as a means of strategic advantage. And you note the fact that there is a line between what is unlawful and what is unlawful. But not everything that is unlawful, is an act of war. Sometimes you can do something unlawful, but it is not an armed attack under Article 51. Now, sometimes it can be lawful, but it can be unethical. It violates certain rules, not necessarily legal rules. Why we say they violate the rules-based order. One example of a gray zone, image was already shown, when they built an island within the EEZ of the Philippines without Philippine permission and created a vast area of damage without, however, attacking Philippine vessels. Hence, it was not an armed attack, it was in fact a gray zone action. And as a consequence of this, there has been a pattern of increasing control as enunciated by a great article I commented by Professor Andrew Chubb on how creeping policy of increasing controls in the 1950s taking advantage of gaps or power vacuums. For example, after the Battle of Dien Bien Phu, as we know, France had to evacuate Vietnam Indochine in 1956, and so they entered the Paracels. After the Paris Peace Agreement, wherein the United States agreed to evacuate Vietnam, they took the Paracels. After the drawdown of Soviet forces in Cam Ranh Bay, they entered the Strathleys and even went into an armed action against Vietnam. And after the Philippines kicked out the Americans in 1991, leading to the evacuation in 1992, we have now the entry into Mr. Free. Hence, it's a pattern of creeping control, as noted by Professor Chuck. There are, of course, other theories as to why sometimes it escalates, sometimes it de-escalates. But his theory is that it's a consistent policy rather than a mere reaction to external forces. So what are the global implications? As noted yesterday by one of the speakers in Turkish, there are regional problems with global implications, and this is one of them. Because UNCLOS is a package deal which made nobody happy. Nobody's happy with UNCLOS. The Philippines is not happy with UNCLOS. We objected to UNCLOS right after we signed it. So, but practice, it's a package deal which made everyone unhappy. What China is doing is not only proposing an interpretation of a parallel norm to UNCLOS. It is using this as a rationale, not for its own legitimate claims, but rather for a vast power grab for strategic reasons. And what is significant as well is that this is accompanied by a new pattern of contesting physical control. Although you might say it's not entirely new, because as noted, for example, by maritime theorists, you always use maneuver warfare rather than Clausewitzian and Jominian attack in order to get advantage at sea. So instead of first conquering the area and then sending your government to occupy it, what they do is they send their government to occupy it and use that as a counter pressure to force the person to acquiesce to a new fait accompli. So basically putting the takeover before the attack, and as a consequence, leading to an act of conquest, but not conquest through force. And why is that important? Because if that is legitimized, we must know that the state is limited by many forces, but only one of them is law. We all know that law is not necessarily the most effective restraint upon state action. It has to be counterbalanced by ethics, by public opinion, and by power capabilities vis-a-vis other states. And international law, as enunciated by Grotius and his predecessors, is founded on the idea that above the state there is another authority. In the West, they call it natural law. I believe in the Islamic tradition, we recognize that the Al-Quran and the Al-Sunnah is higher than the state. In other traditions, that is the same thing. The state is not ultimate authority. However, if you remove law and morality and opinion, all you're left with is power. That is the global implication of what is happening in the South China Sea. If they are able to justify what is being done, then the law as a control, ethics as a control, and public opinion as a control is weakened. And all you're left is a contest of power. And that is dangerous in a powder keg in the region. Summarize it very, very briefly. So what are the equitable ways forward? There are many equitable ways forward. Right now we have the COC negotiation, which has been delayed for so many years, since it really began in 2002. We have bilateral efforts, like the bilateral consultative mechanism of the Philippines and China, but I would like to highlight one of them which has already been mentioned, which is the South China Sea arbitration, because of its significance insofar as its contents. What does it contain? There are actually two awards. One is the 2015 Award on Jurisdiction and Admissibility, and the second is the Award on Merits of 2016, July 12th. The most important content of the 2015 Award on Jurisdiction and Admissibility is that entitlement to maritime zones is distinct from territorial title, and it is distinct from the question of maritime delimitation. As a consequence, even if a delimitation is excluded from the compulsory dispute settlement, the question of maritime entitlement is not. And also, it noted the fact that before you go to dispute resolution, you don't need a formal negotiation, only an exchange of views in good faith. And from the award on merits, there is no historic claim, a maritime entitlement that is not consistent with UNCLOS. The character of island is based on natural capacity, and some acts are illegal not just under UNCLOS but also under the Convention on Biological Diversity as well as the call regs. And of course, they expect good faith compliance with UNCLOS. I don't know how much time I have left, but in any case, what is the systemic import of the arbitration awards? Awards, plural. Number one, it affirmed compulsory dispute settlement under UNCLOS. As noted by, as noted by Professor Poe, that it may be, you may question whether or not the tribunal was entirely wise to proceed notwithstanding the very vociferous objection, because it's a question of effectiveness as opposed to validity. Because validity and effectiveness are two different things, as noted by Hans Kelsen. Something can be valid but not necessarily effective, and that is what happened here. But regardless of that, it is in fact legally valid because by signing onto UNCLOS, you also sign onto the compulsory dispute settlement mechanism. You have consented, even if you render it ineffective by your opposition. Also, another important consequence is that they have separated the maritime from the territorial question. Most of it at least. Both on the substantive issues as well as the procedural and availability of remedy. Another very important thing is that by affirming the natural capacity standard, they have in fact created, if I may use it, a China wall around new coastal state expansion. And they have in fact protected the extent of the common heritage of mankind from over-expansion of coastal state jurisdiction. There are many other points, including the fact that entitlement of littoral states, including China, has been affirmed in the Asian continental shelf, and the illegality of gray zone, not necessarily under Article 51 of UNCLOS, but under other norms, especially call regs, as was mentioned yesterday. And above all, they have now laid down the ground rules for future competition and cooperation. No one has one yet. It has provided the rules for future competition and cooperation, especially by identifying the South China Sea as a semi-enclosed sea covered by Part 9 of UNCLOS, and therefore with possible multilateral cooperation among all the littoral states, as well as relevant user states and international organizations. This is a very important element, because by eliminating the 9-dash line pink area, you have basically isolated the territorial question of the islands. And therefore, you have rendered possible a solution of one, even if the other is not yet fully resolved, because of political or other reasons. And what is therefore the step for the international community? Of course, as we know, as with all arbitral awards, this is only directly binding only on the arbitral parties. That is in fact the exact word of UNCLOS. However, as we know, under Article 38 of the International Court of Justice, arbitral rulings are a secondary source of international law. And as we know from the Vienna Convention on Law of Treaties, subsequent practice of states is a basis for interpreting treaties. And so what is appropriate for us is to make this part of our subsequent interpretation, and also to help persuade China, not to surrender, but to negotiate in good faith. I would like to highlight the example of Latin America, wherein after the arbitration of Chile and Argentina, there was a large process. 1978 almost went to armed conflict. There was attempted mediation by the Holy See in 1982, and finally the Treaty of Rome in 1985. Arbitration is not the end of the story, but it should be the basis for negotiation in good faith. And that is what the Philippines, and I suppose everyone else in South China Sea would want for. A basis for multilateral cooperation, not on the basis of force, but on the basis of law as interpreted by an arbitral tribunal with valid jurisdiction. Because, again, other things we can use the award for, we can use it as a basis to affirm the illegality of coercion short of force. Remember that the international system of today was stabilized partly because of the Charter, and before that by the Stimson Doctrine, saying that the states must not recognize conquest by force. But what if conquest by means other than force? This is the beginning of rendering invalid coercive methods of getting territory and maritime control. And furthermore, and of interest to the landlocked states, this will also be a basis for preventing the overexpansion of coastal state areas by declaring that henceforth any expansion must be made on islands as islands in their natural state. fully entitled islands only in their natural state. That concludes my presentation. Thank you all very much. If you wish to ask any questions, my email is there. Thank you.
Thank you very much, Mr. Silva, for your comprehensive presentation and analysis on the China's actions, particularly in the South China Sea. And I'm sure it triggered a lot of questions in minds, and you will have some time for answering them. Now, our third speaker is Mr. Robert Volterra. Mr. Volterra has been recognized for many years in the global legal directories as one of the world's top public international law practitioners. He is qualified as a barrister in Canada and as a solicitor advocate in England and Wales. He advises and represents governments, international organizations, and private clients on a wide range of contentious and non-contentious public international law and international dispute resolution issues. He regularly acts as a co-agent, counsel, and advocate before the International Court of Justice and ad hoc international arbitration tribunals. He is on the UK Attorney General's A-list for public international law practitioners. Floor is yours.
Thank you very much, and my thanks to the organizers of this conference for having invited me. I have the title of professor. I teach at the University of London, but I am primarily a professional public international lawyer. I'm a professional practitioner. I'm not an amateur academic who occasionally advises governments. And I'm going to speak to you from the perspective of a professional private lawyer in practice. I have been involved in international dispute resolution state to state for 30 years. My first case 30 years ago in the ICJ for New Zealand against France, nuclear test case. My most recent judgment was for Kenya against Somalia in the Maritime Institute of the ICJ. Sometimes I'm on the record of the cases and plead in the ICJ. Often I'm not on the record for various reasons because I practice international law. The practice of international law is real. It's not theoretical. Hard decisions have to be taken, hard decisions made. And one thing that academics have trouble dealing with is that theory is theory. Law is a language. It's used by courts, tribunals, and professional lawyers to argue about shaped outcomes. There was a question earlier before lunch about the law of the sea, interpretation of islands, and if that's customary international law and so on. There's many answers to that on a legal level. On a practical level, if you look at the cases, even the ones that have been cited, almost every tribunal deals with islands in different ways. They refer to the same legal standard and they apply it in entirely different ways, including other carve-outs of islands, to giving them full weight, no weight, some weight, and the size, population, and habitation has nothing to do with the actual outcome. So what I'm going to try to do, I was asked to do, is to try to lift the veil to show you what actually happens, and I was asked to do this in a number of cases relating to my clients in maritime implementation in Africa. And I'm going to put three propositions to you before I start. The first is, any litigator, anywhere in the world, in any system, national or international, any professional litigator will tell you that apart from constitutional cases, litigated disputes, including maritime boundary disputes, are decided not on the law, but on the facts. Ignore that, and you will lose. Second of all, if you were a state with a maritime limitation dispute, who would you want to be your lawyers? Your real lawyers, not the ones for the newspapers, but your real lawyers. Well, imagine you're sitting on a plane about to fly back from Montenegro to Turkey, wherever you're living. And you're sitting there with everybody, and someone comes onto the front of the plane and says, "Ladies and gentlemen, we'd like you to vote for who is going to be your pilot The first person steps up and says, I am an aeronautics professor and I occasionally consult for airlines. The other person steps up and says, I'm a pilot, I've been a pilot for 30 years and I fly every day. Who are you going to vote for? If you are unfortunately having to have a brain operation and someone comes into the operating theater and says, who would you like to be your doctor? The first person stands up and says, I have been a professor of brain surgery for 50 years and I occasionally consult for hospitals. And the next person stands up and says, I have been a brain surgeon for 10 years and I operate on brains every day. Who are you going to choose? Think about it for states in these sort of disputes. The third proposition, statistically, 85% of cases on a state-to-state basis, including maritime delimitation cases, before the International Court of Justice or another international court of tribunal, where one state party is represented by a real public international law firm practice, and the other has amateur academics, 85% of the time, the state with the professional lawyers wins over the last 25 years. You can look up the statistics yourself. The other thing you need to remember before I start, see, I'm a professional, is that you cannot read what actually courts or tribunals are thinking about these maritime delimitation cases by reading the awards or the judgments. You cannot, and I'm going to show you. You also have a very difficult time knowing what parties have actually pleaded and what courts and tribunals are paying attention to. I'll give you one small example. It's been clearly stated by courts and tribunals dealing with maritime delimitation cases, both inside UNCLOS and outside UNCLOS, that oil activity is not a relevant factor to deal with in terms of the relevant factors to take into consideration in an equitable result. All the tribunals say that. And yet, actually, when you're standing up in front of the tribunal in a hearing, where one party has submitted evidence on oil activity, the tribunal asks questions. They are engaged. You see them take notes. You know they are paying attention to it. And if you look at the outcomes, and if you know what the pleadings have been, and if you were in the hearings and you saw all the documents submitted, many, many times the outcomes just happen to reflect the actual facts. So I'm going to start off with Ghana, Côte d'Ivoire. You all know that's on the western part of Africa, on the Gulf of Benin, and they had a dispute about their maritime zones, and they couldn't agree to limitation. Now, there were a few keys to the outcome of this. One was Ghana had hired a professional law firm that had a professional practice that had experience in maritime delimitation negotiations and disputes. And Ghana, therefore, had prepared facts for many years before coming to confront Côte d'Ivoire. Côte d'Ivoire had no preparation, had not done anything in advance, and it hired a small French law firm that had done some other work for the government, and they had no experience in this whatsoever. Now, both sides got some of these amateur law professors to sort of front things up and so on, but the work was actually done by these two law firms. One law firm had absolutely no experience. And so, there were two things that determined the outcome of this case. One of them was that Ghana began engaging in oil activity. And what Ghana did was, it determined the outcome that it wanted to achieve, and it worked backwards. It then determined what the limitation line it wanted, in terms of where the oil was and was not. It determined what claim line it should put, and on what basis it could argue the claim line. It engaged in offshore oil licensing to reflect consistently its claim, but it only actually did drilling inside the area that it really wanted for itself. That was the first thing. The second thing was that during the course of discussions, negotiations, and in front of the tribunals, Ghana managed to completely fool Côte d'Ivoire, and they confused which coast was going to be the relevant coast, and therefore which areas of proportionality were going to be used. And lo and behold, you can see what they convinced the tribunal to consider is the disputed area. You'll notice that the part, almost all of it, comes what you would say is underneath Côte d'Ivoire's coast, right? And only a small part of it is under what you would call Ghana's coast, which means that once everything was decided, oh look, oops, sorry, oh look, in fact, Côte d'Ivoire won because the blue part is what Côte d'Ivoire got. Yay, we got the biggest part! But actually, Ghana got the part underneath Côte d'Ivoire that it wanted. So those are the two things that actually won the case. Everything else in the case that you read in the judgment, doesn't matter. That is what won the case. I put down here then the next example, Nigeria and Sao Tome and Principe, because it was a very important example of a joint development zone that was put forward. And as His Excellency quite rightly put, there are not that many joint development zones in the world. The most recent one, of course, is one to which he alluded. Many of them are actually not well known. I had the pleasure, the last one I did was about 2 years ago in the Caribbean basin for two countries. I did for one country. The joint development zone. I'm not sure it's public yet, but it's a very effective way of dealing with disputes. The zone between Sao Tome and Principe, small group of islands in the Gulf of and Nigeria, of course, an enormous country, is reasonably complex. It's got 3 zones, and the different zones have different allocations and different management regimes and so on, but it suited the party. It suited the party. And even though Nigeria ends up in any objective way of looking at it as being the party with the most benefits in the largest area, in fact, if you look at it from a very realpolitik sort of way, tiny island, big country, no oil and gas experience, would have to give up huge amounts of revenues to get effective oil company investment in the country, or free oil investment from the country which already has the infrastructure and the money. It's actually not a bad outcome if you look at it globally for them all. There is a dispute going on now between Equatorial Guinea and Gabon, so I'm just going around the coast of Africa. These are just selected disputes. And there you can see Equatorial Guinea is a very interesting country. It has both an island and a mainland component, but almost all of the population is on the island, which is not a tiny island, but almost all the population is on the island. And it is one of the wealthiest countries in Africa, if not the wealthy on a per capita basis, because of its oil revenues. It's actually quite a wealthy country. And it has experience in the International Court of Justice and in international disputes. And this is another example. For a very long time, it worked with its U.S. International professional lawyers, professional international law firm, setting up all the facts and background. And it did a number of things in relation to the disputed area in the waters, particularly the 3 islands in dispute. But Gabon is also a reasonably well-managed country in terms of legal preparedness, and they hired professional lawyers in time, and they managed on the ground to start confronting Equatorial Guinea's attempts to change facts and create facts on the ground. This led to some armed conflict, and then some mediation, and there's ongoing dispute, and it looks like it's going to possibly to end up in the International Court of Justice if the parties don't take it out for some conciliation along the way. And again, you can see it's all driven by oil and gas, and both sides are going to plead that heavily. If it gets to the International Court of Justice, of course, the court will say this doesn't matter, etc., but they will look back at some of the historical oil activities, and I have no doubt that they're going to take that into account in their outcomes. Tanzania, Malawi, it's a maritime dispute, but I put it in there because it's an interesting one. It's not law of the sea. It is lake. It is fresh water. And it's a bit like the Caspian Sea in the sense that there is a dispute about applicable law between the parties. Of course, none of the parties are arguing that it is a law of the sea convention situation, but there's a discussion about whether the principles of the three-step methodology that the International Court of Justice affirmed in one of my cases for Bahrain against Qatar as the methodology to approach delimitation under law of the sea convention, whether that should be applicable here or not. In fact, in international law, many lakes are divided not according to any kind of median line, and there are quite a number of examples of international lakes where the entirety of the lake or large parts of the lake are randomly part of one country and not another as a result of historical agreements. In this particular case, the three countries that are littoral states are Mozambique, which is bottom right, top right, Tanzania, and then Malawi. And the reality is that the historical treaties clearly gave the entirety of the lake to Malawi, except for the southeast part, which was given to Portugal, and then obviously taken state succession by Mozambique. What Tanzania began doing from about the 1980s onwards was it saw that it wanted the resources, or the potential resources of Lake Malawi, and it began a process of creating facts. So it began essentially colonizing the Tanzanian coast of Lake Malawi, which was almost unpopulated for different reasons. It had no population. And they began about 15 years ago they got a motor road for the police, began doing some activities. Poor Malawi has been caught unawares. Tanzania is using a professional law firm and has been for a while. Malawi, it's just very unfortunate that one of the poorest countries in Africa, they have so many challenges and issues facing them, and they've just been unable to prepare themselves. And it's one of those examples, a bit like Iran's actions against the United Arab Emirates in the Avrasya Hukuk Islands in the Gulf of Arabia. The passage of time, Tanzania is just taking over more and more of the lake and its operations. So that's an example of how one needs to keep on top of these things. And then final two, Kenya and Uganda and Lake Victoria. Again, this is a maritime dispute, but a lake dispute, and the same sorts of things. An island began appearing through natural causes, falling clearly within the area of Kenya according to colonial treaties. Uganda, at the same time as it had just invaded the Democratic Republic of Congo and occupied its northeastern corner for about 5 years, very aggressive, and it essentially took over the island militarily, threw off the Kenyans, and that is another example of a country that is seeking to attempt to manipulate facts in order to create legal outcomes, and who knows if they'll be successful. They're the same lawyers that have done the same thing against Costa Rica from Nicaragua. So the final one I'm going to talk about is Somalia, Kenya. And this is another fantastic example of how these things actually take place. So you can see the bottom line where it says Somalia's claimed boundary. That's the equidistant line. More or less, and there's some discussion about the facts, but that's the equidistant line. Kenya wanted to have a directly parallel line going out. Kenya said that all the countries along East Africa in the post-colonial couple of decades had agreed to use that methodology. And there are examples of that, up and down. Somalia didn't want to do so. Somalia began having oil and gas exploration, and the oil and gas companies sponsored a professional law firm who has experience in doing these things to begin a process, about 5 years, creating facts and arguments on the ground, trying to change the situation. Kenya used a group of amateur professors, well-known, but amateur professors, and as usual, they didn't examine the evidence because they're not professional lawyers. And Somalia and their lawyers submitted perhaps a dozen sort of fraudulent type evidences, and the academics working for Kenya didn't find them, and they didn't address the arguments. What Kenya then did was it started hearing this from some of its allies internationally, fired its lawyers, they hired us, and we went in, we discovered the fraudulent misleading documentation, but the pleading had been finished. I found a way to manipulate the rules of the International Court of Justice against the court's ruling to submit, under cover of pleading notes that we tricked the Somalis to agree to, and we appended a 300-page new submission making the proper arguments, submitting new evidence, which hadn't been put on the record. And the outcome was, if you read the judgment of the ICJ, it's almost verbatim taken from that last submission that we made a month before the hearing. And the ICJ ruling, somewhat splits the claims, but if you think that Somalia's claim is the equidistant line, that's a huge win for Kenya. Now, for domestic political reasons, Kenya complained and so on, and Kenya withdrew from the case against my advice. That was very silly, but the outcome was if you read the dissenting opinion of the Somali judge on the ICJ, you'll get a view of what Somali really thinks about that. So that was really good fun. So I tried to give you a bit of a flavor of this. I know the next speaker is the agent from Costa Rica. For one of my other clients, a major international power, I was asked to review all of the pleadings and documents in the last 3 cases of Costa Rica and Nicaragua. And certainly in the pleadings, it didn't show that Costa Rica had caught the fraudulent and forged documents submitted by Nicaragua and their lawyers. So I'll be interested to see there are about 3, 4, and 5 in each of the cases. So has Costa Rica figured it out? By the way, Costa Rica uses amateur academics.
Thank you very much. Mr. Kurultay'a gave us very good examples from not too much popular area, Africa. We don't know too much about it, but we have to learn about it. What I learned from this presentation that do not hesitate to hire a professional lawyer. Okay? Pay money, and it will work.
A lot of money.
We poor academics, we don't have this capacity. Okay. Now I give the floor to Mr. Ambassador Arnoldo Renes Castro. Ambassador Castro is a lawyer graduated from the University of Costa Rica in 1991. He obtained a master's degree in theory and practice of human rights from the University of Essex, UK in 1994. He worked at a private law firm between 1988 and 1993 and at the Avrasya Foundation for Peace and Human Progress between 1995 and 1999 as coordinator of the Security and Democratization Program. Since 2000, he has served at the Ministry of Foreign Affairs and Worship of Costa Rica as advisor to the ministers, coordinator of international litigations, and coordinator of the initiative to extend Costa Rica's continental shelf, among other responsibilities. He also participated as counsel and advocate in the legal team in charge of the defense of Costa Rica in the 5 cases against Nicaragua, and were heard by the International Court of Justice in the Hague between 25 and 2018. Since December 2020, Mr. Vance serves as an ambassador of Costa Rica to the Kingdom of Netherlands and permanent representative to the Organization for the Prohibition of Chemical Weapons and other international organizations based in Netherlands.
Thank you very much, Mr. Chair. Very happy and very honored to be here today. In this sense, I also want to join in thanking and congratulating the Turkish Law Platform for organizing this event and making it possible for me to be here. I have a limited time, so I will try to compress events that happened between 2002 and 2018 in 15 minutes, I guess. Because if we reconstruct the facts, we'll see that the process that resulted in the establishment of maritime boundaries, both in the Pacific and the Caribbean, between Costa Rica and Nicaragua, is a combination of different approaches and events, starting with good faith diplomatic negotiations, joint technical work, but eventually it had to be resolved by the International Court of Justice. So I will be as brief as possible, and there are of course many details. I will not go into them, but during the question and answer section, I'll be happy to refer to some more details if there is any question about it. This here is the area. As you can see, this is the area as it was before the maritime limitation between Costa Rica and Nicaragua. You see there's a boundary between Costa Rica and Panama, both in the Caribbean and the Pacific, and between Nicaragua and Honduras in the Caribbean. First, okay, what we have here is a map that the Nicaraguan government published in 2002, advertising blocks to give compensation for oil exploration and exploitation. When we found out about this map, the Costa Rica Foreign Ministry, the ministry sent a note to his counterpart in Nicaragua, making it known that those blocks in the south were encroaching upon maritime space that Costa Rica did pertain to it. There was, let's say, a positive response, and the solution that was found was to create an international commission to start negotiating a treaty, a boundary treaty. This commission started work first in the, as you can see, that there's two areas, and let me go back. There's in the Pacific, what's called the Bahía Salinas, which is a common bay, and in the Caribbean, the other side, that's both are the land border terminals, so those will be the points to start maritime negotiation. So in the Bahía Salinas, in the Pacific, the first step was technical work to the bay. Bahía Salinas is a common bay, so we had to be closed. For that, some work was carried out, some field work, to apply an arbitral award from 1898. In the Caribbean, the work started by trying to locate the first market. The first market that was planted at the end of the 19th century. And by the way, that's me in the photo looking at the market. That's in 2003. In the case of the Caribbean, since there was already a case started by Nicaragua against Colombia, the agreement was not to wait until there was a result, but so that the preliminary work consisted of trying to at least find the land border terminus, which eventually that marker was also lost. It was swallowed by the sea. Now, Nicaragua presented a case against Colombia, as I mentioned, and in the submissions, in the written submissions, in the maps that Nicaragua presented, there were different portrayals of the boundary. So you can see those different lines, an orange one, a red one, a green one. All of those were the border lines as portrayed by Nicaragua. So there's another line, say orange perhaps, or a little bit further up north. That would be an estimated equidistance, so that shows how the Nicaraguan claims were clearly encroached upon Costa Rica's entitlement to the waters there. So that there's another map. Here you can see it's a little bit blurry, but the green line is the equidistance. The red line is one of the borders lines set by Nicaragua in the context of a case. So applying Article 62 of the Statute of the International Court of Justice, Costa Rica requested permission to the court to intervene as a non-party. The idea was to have a formal opportunity to report Nicaragua and Colombia of what Costa Rica's entitlements in the were. And we did with the intervention request was submitted. There were oral hearings. During the oral hearings, we presented some documents. And this map here, this one, shows in blue what Costa Rica's claim for maritime spaces in the Caribbean were. So the idea was to ensure that when the court issued the judgment, those areas were respected. Nicaragua claimed that since there was a treaty from 1977 between Colombia and Costa Rica, that whatever Costa Rica had negotiated with Colombia, Costa Rica had lost it. So the treaty, the 1977 treaty, was not ratified by Costa Rica. But in the context of the case, it was clear that the factual basis for having drawn that contract, that treaty in 1977 had disappeared. And Nicaragua's claim was that since that area did not belong to Costa Rica, because Costa Rica has relinquished this negotiation with Colombia, and it did not appear to Colombia, then it would belong only to Nicaragua. To counter that, Costa Rica used the concept of res inter acta. That means literally something acted between others, and eventually the court accepted that. The court did not accept the request for intervention, neither from Costa Rica nor from Honduras, but the goal was achieved insofar as there was a formal opportunity to inform all the parties what the Costa Rican claim was, and indeed when the judgment was issued. As you can see, this is the sketch map from the judgment of the Nicaragua-Colombia case. And you can see that the areas where Costa Rica's entitlements were, it is clear. The result, as you can see there, was that the Colombian entitlements to the San Andres Islands and the archipelago was divided into enclaves. So the waters, the red lines of the border between Colombian and Nicaraguan maritime spaces. So in 2005, Costa Rica had to present a case against Nicaragua for another dispute had to do with a border agreement. So the consequence of that was that the negotiations were suspended by Nicaragua. Between 2002 and 2005, there were 5 rounds of negotiations in good faith, and we did exchange some proposals and we did some work together. But after 2005, it was clear that it was not possible to continue good faith conversations. So another event happened. Once again, Nicaragua published a new map. This was 2010 oil exploration and exploitation map. As you can see, there are some red lines. They show how some of the southern blocks encroach from Costa Rica's maritime spaces. So there were other events. Costa Rica once again proposed to Nicaragua that we started negotiations in good faith, but Nicaragua did not accept. Then Nicaragua presented an extended continental shelf claim, which also was encroaching upon Costa Rica's water, not only Costa Rica's, Panama's and Colombia's as well. So all 3 countries, we protested that before the Secretary General of the UN. And so it was clear that the only solution was to present the case before the International Court of Justice. The case was presented in February 2014. And it was, as we explained, both the limitation for both the Pacific and the Caribbean. So this is, well, we already covered this, but basically, those are the rules for territorial sea, we apply Article 15 of UNCLOS, the method of equidistance, except for special circumstances. EEZ and continental EEZ and Article 74, equitable solution, and continental shelf Article 83, same as EEZ. So what follows is how what the claims of both states were and how the court solved it, applying these rules. What we see here is the conflicting claims. You see the red line on the south, that was Nicaragua's proposed boundary for the territorial sea. The green line further up was Costa Rica's line. The court's judgment, I want to go back again because you can see basically follow Costa Rica's position, because obviously equidistance was being applied very strictly, so there was Nicaragua didn't do much there. Now, with now in the Pacific, again we have equidistance from the point called SP that you see the darker black line. That's the strict equidistance. Both countries coincided with that. But parting from point K, the Nicaragua's proposal for territorial sea went clearly south, whereas Costa Rica's went up. So, okay, now, EEZ, how is the EEZ determined? The court in 2000, I will say, I must speed up. So, basically, this jurisprudence here is very important, because that's the method that the court defines, that's the method the court follows. So, it's basically a three steps that the cases are remaining. The Black Sea case, for the judgment from 2009, first, establish provisional equidistance line. Second, consider if there are factors calling for adjustment. Third, verify equity. That's where we use the proportionality test. Basically, these are the difference, but the lines were taken by both countries, Costa Rica and Nicaragua. It said, first step, determine the relevant cost. I hope you can see it. But on the Costa Rican side, there's a green line. That's the whole Costa Rican coast in the Caribbean. On the Nicaraguan side, there's a blue line. It does not reach the whole coast, but that's what was determined as a relevant coast. Then we projected from the relevant coast, we obtained the relevant area, which is that's where the entitlements can overlap. Then, step number 2, construction of a provisional equidistance line, which is this one. Then the provisional equidistance line is adjusted, taking into account the special circumstances, and of course, in the Caribbean there's the Little Corn and the Big Corn Island pertaining to Nicaragua, so that was one effect. You see 3 lines there. The one further up north is 0 effect to the island. The line further down is full effect, and the court used a medium point, so that's what was considered here as an equitable solution in the Caribbean. So that's the final result. Now, the proportionality test, like I was explaining before, basically there has to be a proportion between the length of the coast and the maritime areas assigned to each country. So we see that Nicaragua's coast is bigger than Costa Rica's, in the relation of 1 to 2.04 in favor of Nicaragua, and the ratio of the maritime spaces is 1 to 2.4 in favor of Nicaragua. So it was very, very much let's say, even. Now, in the Pacific, again, these are you can see the lower line, that was Nicaragua's submission, how the EEZ should be established. The line further up north, that was Costa Rica's submission. And let's see, So once again, same procedure. Determine relevant costs. You only use, when you have indented geography, you have to use straight lines. So that's, and only the coast that has the potential to project in an overlapping way is taken into account. So in the case of Costa Rica, the green lines, they show the straight lines used. In the case of Nicaragua, the purple line. So step number 2, construction of a provision equidistance line. That's basically the design. Again, competing claims. One taking into account the geographical features, the Peninsula Santa Elena on the Costa Rican side. Nicaragua, of course, claimed that the peninsula should not be given in effect. It's unfair, it's unfortunate. In the case of Costa Rica, we did claim, of course, it had to be given effect. So the line is simplified. So that was the final result. Again, the proportionality test to determine if it was an equitable solution. The ratio, in this case, is in favor of Costa Rica, 1 for Nicaragua, 1.42 for Costa Rica. And the ratio of maritime spaces is 1 for 1.30 in favor of Costa Rica. So there you can see more or less what the, if we take into account the original lines we saw in the oil exploration and exploitation map, what's depicted in darker blue is the difference. So that was the final, the result of the case for Costa Rica. And this is the last one. Costa Rica's maritime spaces, you can see in the Pacific, totally enclosed. And since Costa Rica owns the Cocos Island, so that generates its own EEZ. So in the Pacific, Costa Rica has about 538,000 square kilometers. In the Caribbean, we still have to close the boundary with the FAM, the maritime border. That's the only assignment pending. And that's it.
Thank you very much. It is a hard job to summarize 2 big oceans in 50 minutes, Pacific and Atlantic at the same time. Now, with this presentation, we came to final presentations in this final stage. However, of course, as I promised, now we have some time, some 20 minutes for questions and answers before our conclusion. So, for each person who would like to raise a question, please introduce yourself and please pose your question to one person here and for everyone only one question. I'll just start from here and go there, okay? Yes, please. Microphone, please. Starting from the second row. Mikrofonu şöyle verir misiniz çocuklara? En önce başlayalım oradan. Arkaya doğru gidelim. Okay, we will go further. Önce bu tarafa, we will finish this side first and you will go the other side. Yes, please.
Working? Yeah. So I'm Dawud Hassan. I have just a general question on this, a bit of comment that, you know, we all are talking about equity, and we all know that equity is the heart of maritime delimitation. But in terms of equity, the problem with equity is that it doesn't provide any kind of precise principle or criteria to settle maritime dispute in or to achieve equitable solution. Now, although we have Articles 74 and 83 that ensure that two states can come together and make an agreement in good faith and to achieve some kind of solution, but still, those two provisions, important provisions, are very silent about equitable principles to achieve an equitable solution. Now, I'm just here, you know, professional international law is here, and also practitioners are here, and diplomats. I just want to know that do you see in foreseeable future under the current law of the sea regimes and also international law regime, can we find some kind of or we can establish a structured system of equity to solve or settle maritime delimitation based on that specific principle or a structured system of equity. So that's,
And the question goes to the panel, or
I think the panel, it's a very of
do you think it's possible
Thank
to
you.
create a structured system of equity in the field?
Thank you very much. Ahmed Turk, I'm Palestinian. I'm practicing solicitor in England and Wales. I'd like to thank all the panelists. I believe this session was among the best sessions, actually, for me, at least myself. My question is addressed to His Excellency Ambassador Chagay. Sorry if I don't pronounce your name very well. We all, the Palestinians, we are very grateful to Turkey for defending the rights of the Palestinian. And my question is, Turkey played a very essential and crucial role to protect the interest of the citizens of Northern Cyprus. Do you think Turkey can do the same to protect the Palestinian interest in Gaza Sea? Because as we know, actually, Gaza is still under the occupation, under siege, and there is a lot of Gaza oil in Gaza, and we are wondering if Turkey can do the same role to protect the interests of the Palestinians. Thank you so much.
Thank you. Is there anyone from this side? Yes. Professor Şiksal.
Professor Şiksal, Special Advisor of the Turkish Foreign of Cyprus President on International Diplomacy. I would like to ask Professor Volterra. Let's assume that Turkish side hired a good practitioner like yourself. I would like to ask this question I am sure many people are thinking the same. What do you think about Turkish claims in Aegean and also in Eastern Mediterranean? If Turkey decides to carry the case to the International Court of Justice, what do you think about the solid chance of Turkey? And one more small comment. I mean, since I'm coming from TRNC, I think that the law, as you mentioned, should follow the reality, should succeed the reality. And in Cyprus, we are talking about the realities. We are talking about factual realities, not virtual realities. And there is a Turkish Republic of Northern Cyprus, second independent republic within the Turkish world, since 1974. And also, I'd like to hear to the panel about this comment, what do you think about TRNC? Thank you, as a factual statement.
Thank you. He's asking for free consultancy. Anyone else? Yes.
So thank you very much. I'm Professor Elia. Thank you to everyone, but since we are at the end of the session, it is an observation and not a question, and just to be more relaxed at the end of that long and very intensive day, to Mr. Volterra, let me, many professors will have a lot of interest, because the problem to be so intellectual, we need to have a lot of interest. So in my case, one of that is soccer, okay? So let me use soccer to give an opposite argument about your position against a theory. You can never win a match if you don't have a director preparing the theory of the match, and then the team executing the theory and complete the match. So, you have many possibilities to win, as much as strong is your and valid is your theoretical argument. Thank you very much.
If you don't have any more questions, now I will give the floor from the same order of speech from Ambassador Erciyes to this side. Please, Ambassador. Each of the speakers can also have their views about this traction system of equity.
Okay. As regards the equity, as I explained in my presentation as well, with regard to the limitation of EEZ and continental shelf, Article 74 and 83 of the Sea Convention, it talks about equitable solution. But the convention itself doesn't specify what is it. So we have to look at the jurisprudence of the International Court, and I can easily say that over the last 20 years, there's a good jurisprudence defining the equitable solution. Earlier, the speakers made a reference to the three-stage approach as well, but what is, I believe there is a good definition in the jurisprudence of international court. But I have to mention that every issue is unique. Every geography is different. So there is, we cannot come up with a template to be applicable to all geographical situations. As far as Turkey's position is concerned, we make special reference to the presence of islands, and this is one of the special circumstances. The presence of the islands disturbs the equitable solution. Turkey's position is that those islands should not generate any EEZ and continental shelf. I think this question also relates to in the previous section there was a criticism as to why Turkey drove the EEZ lines, the delimitation line between Turkey and Libya. I think Turkey's position is consistent. Turkey's position is, we have the same position both for the Aegean Sea and the Eastern Mediterranean. Turkey's position is that the delimitation between Turkey and Greece in the Aegean Sea, the mainland's delimitation line should be determined in accordance with the mainlands, not the islands. This is Turkey's position, and those Greek islands lying on the wrong side of the median line between the two mainlands should not be given any continental shelf and EEZ areas. This is Turkey's position in the Aegean Sea. Is also applicable in the Eastern Mediterranean as well. That's why the delimitation line between Turkey and Libya determined accordingly. All those Greek islands lying on the wrong side of the median line between the two mainlands were not given any EEZ and continental shelf. The second question as to the Palestinian right, I believe Palestine has made a declaration to the UN with regard to its maritime jurisdiction rights and maritime claims. I think a couple of years ago, Turkey's position is clear, and we're prepared to cooperate with any country in the Eastern Mediterranean, including Palestine as well, except the Greek Cypriots. Why except the Greek Cypriots? Because the Greek Cypriots counterparts are not Turkey, but Turkish Cypriots. Before the settlement of the Cyprus issue, it is not fair for Turkey to sit with the Greek Cypriots in the absence of the Turkish Cypriots to do anything or to engage in any maritime boundary delimitation. So this is Turkey's general position in the Eastern Mediterranean. And I'd like to reiterate the proposal of President Erdogan, 2020 Inclusive East Med Conference proposal. And in that proposal, Palestine is also one of the countries which will be invited to that conference as well. There was another question with regard to and what will be the outcome if the Aegean issues or the Eastern Mediterranean issues are brought before the court. I've talked to a couple of judges, prominent judges. If the Aegean issues, for example, are brought before the court, it will be the mother of all cases, because it's not an easy case. It's not only one issue involved. There are many outstanding issues in the Aegean Sea, and they are interconnected with each other legally as well, starting from the breadth of the territorial sea, the sovereignty of certain small islets, rocks and the islands, the limitation of the continental shelf, and also the demilitarized status of the Eastern Indian Islands. These issues are all interrelated legally with each other. But as I said in my presentation as well, we want to discuss we want to address all these issues with Greece, not just one. We are challenging Greece to take up all those issues, and Turkey is not ruling out any means of peaceful settlement to be agreed together to be based on the mutual consent of both sides. But we are not there yet. Greece continues to claim that there's only one issue in the Aegean Sea. This is not the reality. There are many issues. So we expect them to engage in a meaningful dialogue with Turkey. This is our expectation from us. Thank you.
Thank you, Ambassador.
Good afternoon. I feel competent to answer only the question concerning equity from a policy standpoint. I think yes, there is a tendency to particularize the general rules like equity. However, there is a trend to particularize that, the method, for example, of delimitation. But sooner or later, there will be need for new exceptions in view of new circumstances. There's always in every legal system, there's always a tug of war between particularity and predictability versus substantive justice. You can see this, for example, in the history of common law, where you have common law courts, and eventually you have to have the Chancery Court with the Chancellor because of the exceptions to the matters not covered by common law. You see this even in international law. For example, in the scientific and technical guidelines of the CLCS, you have the emphasis on finding the foot of the slope in the maximum maximorum, and then they say you have to look at other relevant circumstances. For example, if it's a highly indented ocean crust, where you cannot find the exact ocean crust, then you have to look to evidence to the contrary. You look at the practice of human rights, where there's a rule against infringing upon freedom of speech, but then there are so many exceptions. Because there's always a tug of war between the need for a formal, consistent law versus the need to adjust to particular circumstances, which is why there's always a three-step hierarchy between principles, and then standards, and then rules, with the rules being subject to equitable exceptions as the circumstances may call upon. So I do hope, for the sake of all of us, that there will be greater predictability, but I think that will not be the end of the story as new problems crop up. In fact, even the existence of the continental shelf is an exception carved out by President Truman to the old regime of greater Malay development. Thank you.
Thank you. During your presentations, you also underlined the importance of moral values and ethics in international law. I think this equity issue is also very very much related with ethics and values. Yes. And now, yes, Mr. Robert Voltaire.
Thank you. I have three questions to answer. The first relates to the question about equitable outcome. And my answer is no. If you want a bit more, of course, and you were careful, but we always need to be careful. We're not talking about equity, we're talking about equitable result. That's what the convention says. And there's a difference between common law ideas of equity and equitable result. It's a very significant difference. I mean, we say equity, but you use the proper term, but we just need to keep that in mind. These issues in international law, maritime limitation, they, in some respects, can have precision. You can precisely identify an equidistant law. But other things are value judgments, and they're clearly value judgments. And in fact, I would prefer not to have particularized lists and things of what constitute equitable results and factors that go into that, because courts and tribunals just hide behind the formal list. They hide what they're really doing, so you and I can't see it easily. And all courts do this, everywhere in the world, but also international courts and tribunals. And you know, the International Court of Justice is neither international, nor is it a court, nor does it dispense justice. I mean, this is... It's none of those things. It was never intended to be. It was meant to resolve disputes between states. Right? And you think about who sits on it. Almost no one who sits on it has any experience as public international lawyer before they're appointed. None of them have experience as sitting as judges. Some of them have done some arbitration. None of them have been practitioners. Same with the Law of the Sea tribunal. Fantastic courts, fantastic tribunals, but they don't know how to run cases. They don't know procedures. They don't know how to manage evidence. They get fooled all the time. They get fooled all the time. I think to the Bahrain-Qatar case, I exposed that all of the evidence related to Hawar Islands submitted by Qatar was forged. Forged evidence, 81 forged documents. And Bahrain had a jurisdictional phase with academic amateurs who didn't notice it, fired them, looked at all the documents, blah, blah, blah, figured it out. Now the court noted these documents had been submitted, noted that Qatar said they weren't going to rely on them, effectively admitting that we caught them submitting forgeries, but didn't say anything else in the judgment. But, and you'll never know it from reading the judgment, Bahrain also pleaded that one of the maritime features should be considered an island up in the north, and if it was, it would divert the maritime territory in the north, where the oil field, the gas fields were, enormously in Bahrain's favor. And the court found that fact for Bahrain. It could have easily found the other way around. And that was clearly an equitable punishment to Qatar for having submitted all these forged documents. You'll never see it in writing anywhere. Second question I'm going to address is about Turkey's, I don't know if that's Turkey, has to the ICJ. I mean, you had a fantastic answer there. I would say that if the Aegean case ever got to the ICJ, it would be a case that had a true mix of constitutional, public international law, constitutional theoretical arguments, and very, very practical arguments. I don't know enough about how Turkey is managing the dispute, but I can say, I think, with some confidence that until fairly recently, if you think of two boxers in a ring, in English we would say Greece is outboxing Turkey. Turkey might be bigger, have better arguments, but Greece is landing hit after hit after hit after hit on Turkey. And my 2 cents of advice is that Turkey needs to, what we say in English, up its game. You need to up your game and confront Greece in a wide range of geopolitical, legally informed, strategic and tactical actions. I can't tell you what they are. I don't know enough about it. But looking at it from the outside, this has not happened. and Greece has none. They're just looking from the outside. I have no insight on anything. The last one I was asked was the soccer game. Yes. Who here knows the English comedy group called Monty Python? Monty Python. They're a very famous comedy group, and they make silly comedy. One of their little parts of the show was a soccer game between philosophers. And it was a soccer game between the Greek philosophers, the old Greek philosophers, and the rest of the world. And they all wore costumes. So the Greek philosophers had, the togas, and the Confucius had a Chinese traditional costume, and so on and so on. Schopenhauer had a traditional German 17th century, etc. And they went out, there were referees, and there was a crowd, and so on, and there were announcers. So the ball was put down in the middle, and the Greeks were supposed to start. The whistle blew, and the referee went back, and all the players immediately started walking around like this. And the commentators said, there's Socrates, and he's thinking whether a circular ball reflects the way the world is, or whether the constellations of stars moves in a certain way. And then there was Confucius walking like this. And Confucius is thinking about that. So each of the philosophers were thinking about their theory and so on. Secretly, on the team that was not the Greeks, the rest of the world, all of a sudden, the announcer said, there's Franz Beckenbauer. And he's looking around. He can't understand what's happening. He runs up to the ball. He dribbles it through all the players. He scores a goal. The referee gets the ball, puts it in the middle. Beckenbauer scores again, and again, and again. All the time, the philosophers just... So, it is possible for soccer players that do not have a coach to win a game, but it is impossible for a group of coaches without any players to win a game.
Ambassador.
Thank you. Yeah, I would refer to the question about the equitable solution. If it's foreseeable that one position can be developed, I think the system is good as it is. I think it should be flexible because there are different types of circumstances that have to be taken into account. Some human circumstances, other non-human, mostly geographical, human history, presence, and tradition, and interest of population or variance, etc. So I think the method developed by the ICJ in the Romania versus Ukraine case, I think it's a good method. Eventually, it's designed to, at least in the territorial sea, the practice, the jurisprudence is there's a very strict method that is to be applied. But for the EEZ, that flexibility, I think, is healthy. It gives a good margin for the judges to take into account other circumstances, which I think will be very difficult to establish universal rules to be applicable in all cases. I think each case has to be seen separately. And I, for myself, have more faith in judges. I don't think they're so easily fooled. So I also tend to trust in the good judgment of the judges when they apply that method, which, by the way, has an objective test, which is the proportionality test. So there's, let's say, a wide margin for discretionary considerations, but at the end, there's an objective method, the proportionality test, for everyone to determine whether or not the solution decided by the judges is fair or not. Thank you.
And before we finish, Ambassador Erciyes asked for a short contribution.
Thank you. With regard to the soccer analogy, I'd like to add my perspective as well in relation to Turkey and Greece as well. Yes, the coaching is very important, but fair play is also very important as well. As regards the situation between the two countries, we like to play the match. but the other team doesn't want to play it. That is the issue. That is the issue. We are saying we are ready to make a fair game, fair match, but they are saying that no, they want to set a score against Turkey without matching with Turkey. They are saying that we are not ready to discuss any issue other than the delimitation of the continental shelf, although there are many relevant legal issues that needs to be addressed by both countries as well. That's my contribution to the analogy of...
Thank you very much. That's great. Analogies are popular. I would invite please for oil racing, which is our best popular sport. You know oil racing? It's better. We are at the end of this very exciting session, so I would ask you all to give a big clap.
Thank you, dear speakers and esteemed moderator for this valuable panel. Now we will proceed with the closing ceremony. Esteemed MPs, ambassadors, rectors, professors, and dear participants, it is a great pleasure and privilege for us to welcome you to the closing of International Symposium on Current Developments in the Sea and Maritime Law, organized by Turkish Law Platform in cooperation with Ankara University National Center for the Sea and Maritime Law, UMIP. In order to proceed with our closing ceremony, I would like to welcome and leave the floor to our dear Mr. Mustafa Başkara, the CEO of UMIP, to deliver his closing speech.
Distinguished MPs, ambassadors, rectors, professors, and dear participants. It's a great pleasure to greet you on the closing session of the International Symposium on Current Developments in the Sea and Maritime Law, organized by the UMIP and Turkish Law Platform. Behind this excellent symposium that we have witnessed in the last 2 days, there is a great effort. During the preparation period, which have lasted more than a year, Turkish Law Platform and the UMIP personnel gave their best in order to reach the most influential and academic symposium. However, the influence of the symposium will last with the book, symposium book, which will be published very soon. It's difficult to address all names behind the organization, but I would like to specifically express my thanks to Professor Karan and Professor dear Ahmet Akcan, and the UMIP researchers, especially who are behind this success, Berişak Kocabıyık and Seyhan Gül Yılmaz, for their dedication on this process. And also, I would like to thank to our presenters and organization company. I would also like to thank our co-organizers from all around the world. Specifically state that International Maritime University of Panama, Western Sydney University International Center for Ocean Governance, Maritime Institute of Malaysia, US Naval War College Stockton Center for International Law, Spain Maritime Institute, Ibn Haldun University, Australian National Center for Ocean Research and Security, University of Hamburg, the Institute for the Law of the Sea and Maritime Law, and International Maritime University of Panama. As we can understand that organizing such a huge event is challenging. However, thanks to our co-organizers and organization team, we are able to achieve our goal with participation from 42 different countries and more than 250 participants. During the whole symposium, we have received many questions on the status of DEUCAM and who we are, what we do. Therefore, I would like to briefly explain DEUCAM. DEUCAM was established after the Council of Ministers decrees on Turkish National Maritime Research Strategy document and on the recommendation of Ministry of Foreign Affairs of Turkey. Although DEUCAM was established within the Ankara University, DEUCAM has gained the legal entity status as a national center in 2020. And also, I was appointed as the CEO of DEUCAM just after the nationalization of the center. As DEUCAM, with awarenesses that the seas in the world consist of a single sea, the language of the law should be uniform. Therefore, it is one of our main goals to cooperate with foreign centers and organizations operating in the field of maritime law and law of the sea. With this perspective, we have signed international cooperation protocols with various important organizations and universities in the field of maritime law, which are stretching from Australia to the United States. In addition to our international cooperations, one of the DEUCAM's goals is to assist Turkey's aim to become a maritime country, which we call as Mavi Vatan. For that aim, DEUCAM is currently the leading institute in the way of achieving Turkey's rightful desires on becoming a respected player on the international field. In line with this vision, DEUCAM's board of directors and advisory board consists of academicians, representatives from all ministries, from private sector, and NGOs that have linkage to maritime law and law of the sea. With cooperation of the experts in the maritime law, DEUCAM has also been involved in projects with state institutions, and DEUCAM has contributed to the formation of Turkish maritime law policies by presenting comprehensive results from these projects. And we work to increase their national and especially international awarenesses. I won't get into details in those projects because of the time limit. Besides all, works of DEUCAM also conducts certificate programs, workshops, seminars, symposiums, congress, and many other facilities. DEUCAM is a value to not only for Turkey, Turkish maritime sector, but it is also for the DEUCAM international law in many ways, as it can be seen from our 2 days symposium. I hope you have had a fruitful symposium on which you have gained remarkable details on the law of the sea and maritime law. I wish the third Eurasia Law meeting will have all Eurasian countries on collaboration and cooperation through international law of the sea. In our symposium, as we have discussed not only coastal states' rights on the seas, but we also discussed landlocked states' rights, such as Turkmenistan, Uzbekistan, etc. I would like to express my gratitude to our speakers, moderators, and participations who came here to this despite their busy schedules. And also, I would like to especially thank the speakers who will be on the stage on the closing ceremony, MPs Fatih Şahin, Levent Gülgül, and Fazıl Mustafa. And lastly, I would like to thank our main co-organizer, Turkish Law Platform, to organize this symposium. Thank you.
Thank you, Mr. Başkaya, for your thoughtful address. Now, I would like to welcome Fazıl Mustafa, Member of Parliament of Azerbaijan, to deliver his speech. The floor is yours.
Değerli katılımcılar, hukuk alanında
değerli bilimsel çalışmalar yapan hocalarımız, bu Avrasya Hukuk Platforması genelde yalnız bir Türk dünyası için değil, Avrasya mekanı için de çok önemli bir platformadır. Bu yalnız hukuk alanında bir araştırma, belli bir konuları gündeme getirip tartışma bir amacı güden bir kuruluş değil. Hem de Türk dünyası ve Avrasya mekanında olan hukukçuların bir dayanışmasını gerçekleştiren bir kuruluştur. Ve bizim için de çok hoş bir olaydır ki bu kuruluşun ikinci kurultayı, simpozyumu Bakü'de düzenlendi ve çok başarıyla sonuçlandı. Orada da dünyanın farklı mekanlarından gelen hukukçular orada iştirak ettiler ve konuşma yaptılar ve birbirinden insanlar faydalandılar. Bugün de çok değerli konuşmalar, çok değerli bilimsel araştırmalar burada təqdim olundu və insanlar da həm də özellikle bizim kimi dəniz kıyısı olmayan ülkeleri temsil edən belli bir bu alanda da tecrübesi büyük olmayan topluluklar da oldukça bilimsel açıdan yeni verileri, düşünceleri, görüşleri benimsemiş oldular. Ve bu hem de bugün böyle bir durumda biz bu hukuk toplantısı gerçekleştiriyoruz ki bu toplantı uluslararası hukuk çiğnenmiş durumdadır. Uluslararası hukukun güvenliğini korumalı olan devletler kendileri onu ihlal eden devletlere dönüşmüşler. Ve ona göre de bazen dünya beşten büyük söyleyende aslında dünya hukuk isteyen, adalet isteyen dünya beşin adaletsizliğine karşı kendi direnişini ortaya koymaktadır. Ve bu açıdan da bu platformanın büyük tarihi ehemmiyeti var. Ve Azerbaycan olarak da biz bu platformada hem de ben Azerbaycan Hukukçular Konfederasyonu'nu temsil edilen bizim başkanımız Ali ve Hüseyinli, bizim parlamentonun parlamento başkan yardımcısının da selamlarını iletmek istedim. Biz Azerbaycan hem de Milli Meclisi parlamentosu Avrasya mekanında olan devletlerin hem de hukuk alanında belli bir istişare, belli bir dayanışma, belli bir bilgi birikimi konularında da işbirliğinin genişlenmesinden, gelişmesinden yana belli bir tavırlar ortaya koymaktayız. Ve ümit ederim ki bu platformada bunun daha da ileri götürülmesine sebep olacaktır. Biz bu konuları hem de Avrupa Konseyi Parlamenterler Meclisi üyesi kimi Azerbaycan temsilcisi olarak orada da yani gündeme getirmeyi düşünürəm. Herhalde Avrasya Hukuk Platformasının bu cür çalışmaları bu düzeyde de təbliğ olunmalıdır. Ve orada da belli bir diğer ülkelerin de bu konuda dayanışma sağlamasına çalışmalıyız. Bir daha işlerinizde başarılar diləyirəm ve ilerideki daha büyük ve başarılara imza atacak çalışmaları Allah'ın bize nasip etmesini diləyirəm. Sağ olun.
Thank you, Mr. Mustafa, on your speech. Now, I would like to welcome to the stage Deven Bülbül, the Group Deputy Chairman of the Milliyetçi Hareket Partisi.
Evet, ben de uzun bir günün sonunda bu güzel toplantı için bütün herkese başta Türkiye Hukuk Platformu ve diğer olmak üzere bütün paydaşlara çok teşekkür ederek başlamak istiyorum söze. Gerçekten çok istifade ettiğimiz, özellikle hem bölgemizde hem ülkemizin hem de dünyada bugün itibariyle son derece sancılı süreçlerin yaşandığı bir dönemde özellikle bu ihtilaf alanlarının merkezinde olan deniz hukukunun, denizciliğin güncel meselelerini tartışarak belki en isabetli iş yapılmış olabilir. Ben bu noktada tebrik etmek istiyorum, teşekkür etmek istiyorum. Değerli hocalarımızdan çok faydalandık. Çok güzel sunumlar dinledik burada. Güzel tartışmalar oldu. Farklı bakış açılarına şahit olduk. Bunların hepsi bizleri geliştirdi. İnşallah bu çalışmalar daha da genişleyerek, çok daha farklı platformlarda da devam eder. Bizler bu çalışmaların inşallah takipçisi olacağız. Gönül ister ki dünyada uluslararası hukukun tahkim olduğu, daha fazla güçlendiği, uluslararası örgütlerin saygınlığının ve etkinliğinin arttığı bir dönemde yaşasaydık keşke veya bu toplantı keşke böyle bir dönemde yapılabilseydi ama ne yazık ki uluslararası kuruluşların çözüm odağı olmaktan daha ziyade çözümsüzlüğün merkezi haline geldiği, bölgesel çatışmalarda, bir takım anlaşmazlıklarda hiçbir şekilde adaletin ve hakkaniyetin konuşulmadan, etik değerlerin konuşulmadan sadece güç odaklı, güç merkezli bir anlayışla meselelerin çözüme kavuşturulmaya çalışıldığı, uluslararası hukuk kaidelerinin temel ilkelerinin bir tarafa bırakıldığı bir dönemdeyiz ne yazık ki. Bu açıdan bu tür toplantılar burada atıfta bulunarak yine hukuku, yine adaleti, yine hakkaniyeti, yine etik değerleri vurgulayarak bence müstesna bir iş yapmış oluyor. Türkiye açısından biz tabii siyasetçi olarak değerlendirmek durumundayız. Türkiye açısından bakıldığında dünyaya Türkiye'nin baktığı zaviye, bakış açısı, perspektif son derece önemli. Biz bu ihtilafların çözümünde adalet ve merhamet duygusu olmadan insanı merkeze alan bir anlayışla bu işlere bakılmadan meselelerin çözümünde herhangi bir mesafe kat edileceği inancında değiliz. Dolayısıyla Sayın Cumhurbaşkanımızın da Dünya Birleşmiş Milletler Genel Kurullarında ve büyük zirvelerde de dile getirdiği gibi dünyada işten büyük bir ifadesinin hiçbir şekilde hiçbir ülke tarafından küçümsenmemesi gerektiğini düşünmekteyiz. Bu ifadenin son genel kurulda, son Birleşmiş Milletler Genel Kurulu'nda Birleşmiş Milletler Güvenlik Konseyi'nin daimi üyesi olan büyük ülkeler tarafından da, onların başkanları tarafından da kürsüden bu mevcut sistemin işlemediğini ve kilitlendiğinin itirafıyla bu sözün haklılığı bir defa daha ortaya çıkmış oldu. Türkiye şu an denizlerinde bakıldığı zaman öyle bir ülkeyiz ki 8.300 kilometreden fazla, belki yanlış mı söylüyorum bilmiyorum ama kıyı şeridi olan bir ülke olarak Akdeniz'de 1500 kilometreyi aşkın, işte Ege Denizi'nde 2800 kilometreyi aşkın kıyıya sahip olan bir ülke olarak ne yazık ki Meis adası kadar bir hassasiyetle, hakkaniyetle ve adaletle kendisine özellikle Batı, Avrupa Komisyonu, Avrupa Birliği, farklı uluslararası kuruluşlar tarafından ve muhatabımız ülkeler tarafından değerlendirilmemeye çalışılan bir ülke durumunda. Bu tabii bizi yeise kapılmamıza sebep olacak bir durum değil. Bizler bu toplantılar da buna vesiledir. Bizler çalışıyoruz. Nesillerimiz, insanlarımız, bilim adamlarımız bu konularda kafa yoruyor. Siyasette biz bu çalışmaları dikkatle takip ediyoruz. Türkiye'nin hak, alaka ve menfaatlerini her alanda, her şekilde, doğru bir şekilde savunmak için elimizden gelen bütün gayreti inşallah sarf edeceğiz. Ben bu noktada son derece ümitliyim. Fakat işte bizim dışımızdakilerin kavramakta güçlük çektiği şey ne yazık ki Türkiye'nin artan kapasitesi, Türkiye'nin bölgesinde oluşturmuş olduğu etki, aynı zamanda dünyaya vermiş olduğu mesaj anlaşılıyor ki bir takım rahatsızlıklara sebep olmakta. Yani bu noktada Türkiye bu oyunun bir parçasıdır. Türkiye olmadan bu bölgede herhangi bir hazırlığın, herhangi bir oyunun kurulamayacağı artık son derece açık bir şekilde ortaya çıkmıştır. Efendim, İBB'de yapmış olduğumuz anlaşmalardan tutun Kıbrıs meselesinde ve Ege'deki diğer meselelerde de Türkiye gücünü gerekirse sert bir şekilde, gerekirse diplomatik kanallarla da her şekilde ortaya koymaya hazırdır. Fakat Türkiye'nin her zaman öncelediği şey meselenin diplomatik zeminde çözülmesidir. Bu açıdan gösterilen çabaları asla ve asla bir kenara bırakamayız. Bu özellikle Mitsotakis'te Sayın Cumhurbaşkanımız arasında işte biz baş başa bu işi çözelim anlayışının son derece kıymetli olduğunu düşünürken bir anda devamında yaşadığımız hadiseler meseleyi bambaşka bir zemine taşıdı ve bugünkü gerginlikleri yaşamamıza sebep oldu. Bunlar son derece üzücü gelişmeler. Türkiye ile bu anlamda bir güç yarıştırarak bir sonuç alınacağı kanaatinde değiliz. Türkiye bu meseleleri yine büyük bir soğukkanlılıkla takip etmekte. Özellikle adaların silahlandırılması, gayri askeri statüdeki adaların bugünkü sadece Yunanistan tarafından değil, belki işte bir takım yabancı ülke askeri güçleri tarafından da kullanılması noktasında Türkiye gereken çalışmaları yapıyor. Her alanda ve her şekilde buna cevap vermeye muktedir olduğumuzu biz biliyoruz. Fakat meselenin bu bölgede Akdeniz gibi bir barış denizinde, tarihi açıdan değerlendirildiğinde Akdeniz gibi bir barış denizinde bunun başka bir takım sıcak karşılaşmalara sebep olmaması için elimizden gelen bütün gayreti sarf etmeye çalışıyoruz. İnşallah burada akıl, soğukkanlılık ve sağduyu galip gelecektir. Ben buna inanıyorum. Türkiye'nin bu konuda geçmişte Türkiye'ye bakış noktasında bir kalıpla ne yazık ki Batı tarafından değerlendirilmesi. Burada bir talihsizlik. İnşallah bu kalıplar bir şekilde parçalanıp çözülür de bu meseleleri doğru bir şekilde tartışırız. Ben hatırlıyorum işte üniversite öğrencisiydik veya sonrasıydı. Anlam planı görüşüldüğü zaman Gerhard Schröder'le bir Alman şansölyesiyle bir röportaj yapıyorlar Türk kanalında. Bizim spiker işte uluslararası hukuktan kaynaklı Türk tarafının, Türkiye'nin haklarından bahsedeceği bir aşamada Gerhard Schröder kesti spikeri. Dedi ki arada dedi temel bir fark var dedi. Bu dedi ihtilaf dedi, hukuki bir ihtilaf değildir dedi. Bu ihtilaf siyasi bir ihtilaftır. Şimdi mesele tamamen uluslararası hukuk zemininden ve bunun getireceklerinden uzaklaşıp tamamen siyasi bakıldığı zaman popülizme, işte seçim dönemi yaklaşıyor ki ülkede de herkesin ağzında. Bunlara kurban edilebiliyor ne yazık ki. Ermeni soykırım iddialarında da işte tarihçilere bırakılsın diye biz ısrar ediyoruz. Her türlü arşivlerimizi açtık. Ermeni arşivlerini açtık. Arşivlerimiz açık olsun. Mesele bu zeminde tartışılsın dememize rağmen mesele parlamentolarla görüşülerek mesele siyaset temelinde çözüm aranmaya ve bunun Türkiye'ye karşı bir baskı vasıtası olarak kullanılmaya çalışıldığını hep birlikte görüyoruz. Dolayısıyla bizler neyin ne olduğunu farkındayız. Bunu da soğukkanlıkla değerlendiriyoruz. Mevcut şartlara göre Türkiye tedbirlerini alıp gereken aksiyonu da ortaya koyar. Biz buna inanıyoruz. Hepinize teşekkür ediyorum. Sağ olun.
Thank you for your speech, Mr. Beaver. And last but not least, I would like to welcome to the floor Mr. Fatih Şahin, the Secretary General of AK Party, to deliver his speech.
Saygıdeğer milletvekillerimiz, çok değerli hukukçular, kıymetli konuklar, ben de sözlerin başında sizleri hürmetle, muhabbetle selamlıyorum. 3. Avrasya Hukuk Kurultayı'nda bugün burada sizlerle birlikte olmaktan dolayı çok büyük bir onur ve mutluluk duyduğumu ifade etmek istiyorum. Oturumlarda sunumlarını gerçekleştiren bütün panelistlerimize, moderatörlerimize, benden önce konuşan kıymetli mevkidaşlarıma, şahsım, ülkemiz ve partimiz adına şükranlarımı ifade etmek istiyorum. Ben bütün bu tartışmalardan hem bir hukukçu olarak hem de bir siyasetçi olarak istifade ettiğimi büyük bir mutlulukla ifade etmek isterim. Burada oluşan külliyat, burada oluşan birikim eminim ki hukukçulara, hem teorisyen hukukçulara hem pratisyen hukukçulara da hem de siyaset yapıcılara yol gösterici olacak, yeni ufuklar açacak, yeni kapılar aralayacaktır. Bu manada bu tür çalışmaların ülkeler için, milletler için ve insanlık için çok kıymetli, çok değerli olduğunu bir kez daha ifade etmek istiyorum. Avrasya Hukuk Kurultayı'nın bu üçüncüsü. Bundan önce 2014 yılında Bosna Hersek'te, 2018 yılında Azerbaycan'da gerçekleştirilmişti. Bu kurultayın başlığı çok önemli, çok kıymetli, çok da güncel bir konu. Deniz hukukunda güncel gelişmeler. Tabii hukuk çok dinamik bir alan. Deniz hukuku çok daha dinamik bir alan. Sürekli kendini yenileyen, yeni gelişmelerle kendini güncelleyen bir alan. 21. yüzyılda zaman çok hızlı ilerliyor, çok hızlı değişimlere şahitlik ediyoruz. Bu zamanın hızlı ilerlemesi hukuk alanındaki değişimleri de tetiklediğini hep beraber yaşıyoruz. Gerçekten de dünyanın hangi bölgesine bakarsak bakalım, bölgesel manada ve küresel manada çok önemli hadiseler, çok önemli gelişmeler yaşanıyor. Maalesef çatışmalar, savaşlar, gerilimler, gerginlikler yaşanıyor. Hiç şüphesiz ki bunlara karşı insanlığın bir şeyler söylemesi gerekiyor. Hukukçuların bunlara karşı bir şeyler söylemesi gerekiyor. Burada söylenen kıymetli, değerli şeylerin, ileri sürülen tezlerin insanlığın geleceği için daha adil, daha barış içerisinde, daha müreffeh bir dünyanın inşası için çok kıymetli, çok değerli olduğunu düşünüyorum. Hiç şüphesiz ki bu kurultayın gerçekleşmesine katkı veren kuruluşlara hepimiz şükran borçluyuz. Türkiye Hukuk Platformu'nun değerli başkanı Ahmet Akçan beyefendiye çok teşekkür ediyorum. Hamburg Üniversitesi Deniz Hukuku Araştırmaları Merkezi'ne kıymetli başkanımın şahsında çok teşekkür ediyorum. Mezun olduğum üniversitenin bu güzel programda paydaş olmasından dolayı ayrıca memnuniyet ve gurur duyduğumu da ifade etmek istiyorum. Hiç şüphesiz ki kurultayın çok kıymetli paydaşları var. Hepsini sizler zaten biliyorsunuz. Tek tek saymama gerek yok. Her birine ayrı ayrı maddi manevi destekleri için çok teşekkür ediyorum. Bundan önce 2014 ve 2018'de gerçekleşmişti. Bu periyotların çok uzun olduğunu düşünüyorum. Ahmet Bey, belki bu periyotları daha da dağıtmak gerekir. Daha sık bir araya gelmek gerekir. Çünkü burada çok önemli bir külliyat oluşuyor. Bu siyaset yapıcılar için, hukukçular için ve insanlık için çok değerli bir birikim. Bu birikimden daha fazla, daha azami derecede istifade etmek için bu programları daha da sıklaştırmamız gerekiyor sanırım. Tabii ben ilk günü kaçırdım, bunun için de hayıflanıyorum. Ancak katıldığım oturumlarda çok kıymetli görüşlerden istifade ettiğimi ifade etmiştim. Hakkaniyet kavramı çok ön plana çıktı. İyi ki de ön plana çıktı. Ne mutlu ki ön plana çıktı. Türk dış politikasının eksenini oluşturan, Türk dış politikasına rengini veren bir kavramın burada ön plana çıkmış olmasından dolayı bir Türkiye Cumhuriyeti vatandaşı olarak ve Türk siyasetçisi olarak onur duyduğumu, gurur duyduğumu ifade etmek istiyorum. Cumhurbaşkanımız Recep Tayyip Erdoğan, dünya beşten büyüktür derken, daha adil bir dünya mümkündür derken, daha yaşanılabilir bir dünya mümkündür derken, aslında bu düşüncenin arkasındaki yatan temel felsefenin muhalif gücü de hakkaniyet kavramı. İnşallah bu hakkaniyet kavramı çerçevesindeki tartışmalar daha da derinleşir. Burada çok derinlikli, çok zenginleştirici bir deneyim yaşadığımı da ifade etmek istiyorum. İnşallah insanlık için zorlaşan bu günlerde, bu yıllarda bu kavram daha fazla ön plana çıkar, daha gelişir, Hiç şüphesiz ki bunu bir çerçeve içerisine oturtmak çok mümkün değil. Ne kadar sorun varsa belki o kadar hakkaniyetli yaklaşıma ihtiyacımız olduğunu da söylemek mümkün. Ama öyle inanıyorum ki insanlığın sorunlarına çare üretecek, insanlığın yaralarına merhem olacak kavramında bu hakkaniyet kavramı olduğunu burada bir kez daha gördük. Türkiye Cumhuriyeti Devleti son dönemde özellikle uluslararası platformda çok önemli işlere imza atıyor. Aslında Türkiye Cumhuriyeti Devleti son dönemde hangi alana bakarsak bakalım çok önemli mesafeler kat etmiş bir ülke. Uluslararası ilişkiler bağlamında baktığımızda da Türkiye'yi göz ardı edilerek herhangi bir bölgesel ve küresel denklemin kurulmasının mümkün olmadığını artık görüyoruz. Nerede bir ihtilaf varsa, nerede bir sorun varsa orada yapıcı, adaletli, hakkaniyetli yaklaşımıyla Türkiye Cumhuriyeti Devleti'nin olduğunu, Türkiye Cumhuriyeti Başbakanı Recep Tayyip Erdoğan'ın olduğunu, Türk diplomatlarının olduğunu ve bütün meselelere kalıcı, adil, hakkaniyetli çözüm arayışlarının içerisinde olduğunu görüyoruz. Bunu yaparken de kendi ülkemizin menfaatlerinde akılcı bir politikayla savunduğunu görüyoruz. İşte son yaşanan bölgesel ve küresel gelişmelerde buna hep birlikte şahitlik ediyoruz. Bu birliktelik çok kıymetli, çok değerli, çok önemli. Bugün burada 42 ülkeden katılımcılar var. 250'nin üzerinde 300'e yakın katılımcıyla bu program icra edildi. Dünya ortak evimiz. Bugün yine bir şeyin hep beraber bir kez daha farkına vardık ki aslında dünyada tek bir deniz var ve dünyadaki bütün devletler, bütün milletler bu tek bir denizi ve barındırdığı zenginlikleri adil bir şekilde, hakkaniyetli bir şekilde paylaşmak durumundayız. Eğer dünya yaşanılabilir, adil, müreffeh bir küre olsun istiyorsak. Ben son konuşmacı olduğumun farkındayım. Çok yorucu oturumlar gerçekleştirildiğini biliyorum. Onun için sözlerimi çok uzatmayacağım. Genelde bu söylendikten sonra bir yarım saat 45 dakika daha konuşur bunu söyleyenler. Ama ben öyle yapmayacağım. Her birinize ayrı ayrı çok teşekkür ediyorum. Yeni kurultaylarda, yeni programlarda, yeni fikirler etrafında buluşmak ümidiyle diyor. Herkese hayırlı akşamlar diliyorum.
Ladies and gentlemen, that would be all of our closing session. Thank you all for your participation to our symposium. The dinner service will be at Karadağ'ın Restaurant, which is located in the city center. The meeting point for the transportation is the hotel lobby. All guests are expected to be gathered at the hotel lobby at 6 p.m. for departure. Also, on the day of departure, you must check out at the hotel before 12 p.m. At 12 a.m. Staff at the reception will inform you where to put your belongings. Also now we will have a family photo. So may I ask all the participants to come to the stage. Thank you very much. And after the photo, there will be a coffee break and we have a recital outside.
Siz Ahmet Bey, bir geleyle bir gelseniz de.